What may appear at first glance to be a dispute over natural resources between neighboring nations is, in truth, a constitutional question of consequence. When the President of the United States publicly characterizes the freshwater resources of another sovereign nation as though they were a domestic utility, and when members of his administration reportedly suggest that long-standing bilateral treaties are easy to abandon, we are no longer in the realm of rhetoric alone. We are in the realm of constitutional structure, of treaty obligations, and of the rule of law itself. You've heard the language. Canada's vast freshwater reserves described as a faucet, a suggestion that water could be turned on and redirected southward with little more than executive will. Reports that agreements governing the Great Lakes and the Columbia River might be torn up. These are not casual remarks when they come from the highest offices of our government. They implicate solemn compacts that have governed relations between the United States and Canada for more than a century. The Great Lakes are not merely 5 bodies of water on a map. They constitute nearly 1/5 of the world's surface freshwater. They sustain tens of millions of people on both sides of the border. They power industries, support agriculture, enable transportation, and anchor regional economies whose scale rivals that of entire nations. The Columbia River system likewise originates in Canada and flows into the United States, providing hydroelectric power, irrigation, and flood control across the Pacific Northwest. These waters are governed not by improvisation, but by treaties, statutes, and carefully calibrated institutional arrangements. Under our Constitution, the power to make treaties resides in the President, with the advice and consent of the Senate. Once ratified, those treaties become, under the Supremacy Clause, the supreme law of the land. They are not aspirational. They are binding. They do not yield to offhand remarks or unilateral impulses. Moreover, Congress possesses its own constitutional authorities over commerce, appropriations, and the regulation of interstate and foreign affairs. When the United States entered into the Boundary Waters Treaty in 1909, and when Congress approved the Great Lakes Compact in 2008, it did so pursuant to these constitutional powers. Those instruments have endured through wars, economic crises, and political realignments. The Great Lakes Compact, in particular, was enacted as federal law and joined by 8 American states. It restricts large-scale diversions of water outside the basin. It represents an exercise of federalism in its most constructive form. States acting in concert with Congress to safeguard a shared resource. No president may simply wish it away. To alter it would require legislative action, state participation, and compliance with the constitutional processes that bind us all. There is, as scholars of water law have long observed, a structural reality that no executive order can repeal. Water flows downhill. Geography shapes power. Nations situated upstream possess leverage that downstream nations ignore at their peril. That is not a political slogan. It is a fact of nature, and international law has evolved in recognition of it. Cooperative treaties exist precisely because unilateral action in such contexts invites instability and retaliation. When public officials speak of abandoning these frameworks, the constitutional stakes are immediate. The separation of powers is not a technicality. It is the mechanism by which we prevent the concentration of authority in any one branch. Treaty commitments cannot be discarded by implication. Statutory compacts cannot be nullified by assertion. If they could, then the reliability of the United States as a treaty partner would rest not on law, but on the disposition of a single officeholder. History counsels restraint. For more than a century, the United States and Canada have managed shared waters through institutional channels, not through threats or improvisation. That record reflects a deeper constitutional truth. Durable governance depends upon fidelity to process. When we depart from that discipline, even rhetorically, we erode the expectation that law governs power rather than the reverse. You may be tempted to view this episode as mere political theater. I would urge you to look more closely. When treaties are described as expendable and natural resources as objects of unilateral claim, the underlying question is whether constitutional limits still mean what they say. That question does not concern one president alone. It concerns whether we, as a constitutional republic, will insist that power be exercised within the bounds our founding charter prescribes. It is important to understand precisely what is and is not within the authority of a president in this domain. The executive branch conducts diplomacy. It negotiates agreements. It represents the nation in its dealings with foreign sovereigns. But it does not own the law. When the United States entered into the Columbia River Treaty, and when it reaffirmed cooperative management of the Great Lakes through statutory compact, those arrangements became embedded in a legal framework that binds successive administrations. The continuity of law across presidencies is not an accident. It is the very condition of constitutional government. Reports that ongoing negotiations to modernize the Columbia River Treaty were paused or abandoned deserve scrutiny not as a matter of policy preference, but as a matter of institutional responsibility. Modernization efforts are typically the product of years of intergovernmental dialogue, technical study, and legislative consultation. They implicate flood control, hydroelectric generation, environmental stewardship, and indigenous interests. To suspend such a process without transparent explanation is to introduce uncertainty into a framework designed for stability. Uncertainty in international water management is not merely inconvenient. It carries economic and geopolitical consequences. Equally significant is the suggestion that long-standing partners might be excluded from forums historically devoted to joint stewardship. Diplomatic summits and bilateral commissions are not ceremonial niceties. They are instruments of structured cooperation. When representatives of a neighboring country are disinvited from discussions about shared waters, the message conveyed is not one of strength. It is one of instability. Institutions function on predictability. When predictability erodes, so too does trust. The Constitution does not speak in detail about rivers or lakes. It does something more profound. It allocates power in a manner intended to restrain impulse and require deliberation. Congress regulates commerce with foreign nations. The Senate must consent to treaties. The states retain sovereign interests, particularly when natural resources within their borders are concerned. The Great Lakes Compact reflects this layered sovereignty. It is an agreement among states, approved by Congress, integrated into federal law. It cannot be undone by executive preference alone. Some have argued that presidents possess inherent authority to withdraw from treaties. That question, debated in academic circles, is not settled in a manner that would permit casual abandonment of a regime so deeply intertwined with domestic statutory law and state compacts. Even if withdrawal were theoretically possible in some contexts, it would not dissolve federal statutes or interstate agreements enacted pursuant to Congress's enumerated powers. Law does not evaporate because diplomacy shifts. You should also consider the reciprocal dimension. International agreements are rarely one-sided. The United States benefits from Canadian water storage that enhances flood control and power generation in the Pacific Northwest. American communities rely on predictable flows governed by treaty. If cooperation were replaced by confrontation, upstream control becomes leverage. That is not conjecture. It is the structural reality of transboundary water systems. The law of nations evolved precisely to temper that leverage through rules and mutual restraint. When public discourse reduces these complexities to imagery of faucets and plumbing, the danger lies not in rhetorical flourish alone, but in the normalization of executive unilateralism. If citizens come to believe that any resource, any treaty, any statutory compact can be overridden by assertion, then the constitutional architecture that mediates competing interests is weakened. The rule of law depends upon a shared understanding that power is constrained, even when constraint is inconvenient. Our history offers cautionary examples. In moments of crisis, presidents have claimed expansive authority. At times, the courts and Congress have acquiesced. At other times, they have resisted. The enduring lesson is that institutional equilibrium is maintained not by accident, but by vigilance. When one branch presses beyond its bounds, the others must respond, and citizens must recognize what is at stake. This controversy, therefore, is not about water alone. It is about whether constitutional processes will continue to govern the management of shared resources. It is about whether treaties remain binding commitments or become transient policy preferences. And it is about whether federalism, carefully constructed in agreements like the Great Lakes Compact, will be respected as law rather than treated as an obstacle. The deeper constitutional concern emerges when we consider the cumulative effect of such assertions. A president may, in the course of political advocacy, describe ambitious goals or challenge existing arrangements. That is part of democratic debate. But when the language of ambition blurs into the language of entitlement over resources secured by treaty and statute, we approach a line that the Constitution was designed to prevent us from crossing. The founders did not construct a system in which foreign commitments could be recast as domestic assets at the discretion of a single office. The Boundary Waters Treaty of 1909 has endured because it reflects a recognition that geography compels cooperation. It created mechanisms for joint oversight, dispute resolution, and technical evaluation. Its durability across wars and ideological shifts underscores a principle that is easily forgotten in moments of political intensity. Stability in international relations is achieved not through improvisation, but through institutional continuity. When a president signals that such continuity is optional, even rhetorically, the signal travels far beyond the immediate dispute. You should ask yourself what message is conveyed to allies and adversaries alike if treaties governing shared natural resources are described as easy to abandon. The reliability of the United States as a negotiating partner rests on the expectation that its commitments survive electoral cycles. If that expectation erodes, so too does the willingness of other nations to enter into agreements with us on matters far more consequential than water. Trade, security, environmental protection, and collective defense all depend upon confidence that our constitutional processes will be honored. There is also a domestic dimension that cannot be ignored. The Great Lakes states, acting through their legislatures and governors, join together to safeguard a basin that sustains their economies and communities. Congress approved that compact, transforming it into federal law. This is federalism in action. States exercising sovereignty within a national framework. If executive rhetoric suggests that such arrangements are obstacles to be circumvented, the equilibrium between national and state authority is unsettled. The Constitution does not contemplate a presidency that may displace state-sanctioned compacts by declaration. Consider as well the economic interdependence at issue. Hydroelectric generation in the Pacific Northwest depends in part on upstream storage in Canada. Agricultural irrigation, commercial navigation, and municipal water supplies are calibrated to treaty-based expectations. Disruption in one segment reverberates across the system. Law, in this context, functions as infrastructure. It channels expectations, stabilizes investment, and reduces the risk of conflict. To treat it as expendable is to treat the underlying economic architecture as expendable. None of this is to suggest that treaties are immutable or that renegotiation is forbidden. The Constitution anticipates change through lawful means. Presidents may propose revisions. Congress may enact new legislation. The Senate may consent to modified terms. States may participate in updated compacts. What the Constitution does not authorize is the bypassing of those mechanisms in favor of unilateral assertion. Change achieved through process strengthens legitimacy. Change imposed without process weakens it. The ultimate danger lies not in any single proposal, but in the habituation of the public to the idea that structural constraints are mere technicalities. If we come to view treaties as disposable and compacts as inconveniences, we erode the very safeguards that protect us when power shifts hands. Today's assertion of unilateral authority may align with one's policy preferences. Tomorrow's may not. The Constitution's restraints are designed precisely for that variability. As citizens, your responsibility is not to master every technical detail of water law or hydrology. It is to recognize when institutional boundaries are tested. When you hear that a president seeks to tear up agreements that have governed international conduct for generations, you should inquire not only whether the policy is wise, but whether the method respects constitutional order. The preservation of the Republic depends less on the outcome of any particular dispute than on the fidelity with which we adhere to the processes that legitimize governmental action.